All right. Well, I'd like to welcome everybody for taking time out of their busy week and especially on a Friday afternoon to talk about some of the copyright and technology and some of the compliance and uh, guidelines that a lot of you have inquired over the past few months, especially with remote learning. My name is Jeff Craven. I'm the executive director of both NAMTech and AIM, and we are so happy that we can have Carolyn Martin from Lutzker and Lutzker, as well as Ethan Barr on the call today to really kind of talk about some of those policies and kind of reaffirm and answer some of the questions that you may have. If you have any questions or anything like that, please feel free to put them in the chat, and we will forward them and have Carolyn and Ethan answer those questions. Again, I want to thank everybody for attending, and thank you, Ethan and Carolyn, for your time. With it, I'm going to go ahead and I'll turn it over to Carolyn and Ethan.
Good afternoon, everyone. First, thanks to Jeff for inviting me to attend, and I invited Ethan to join me. Ethan is a intern with our firm, and fortunately, he has accepted an offer to join us permanently in September. Ethan's particularly well suited to this conversation because prior to attending law school, he got his master's in education, leadership, and policy studies from Boston University has also taught for 5 years, as well as serving in administrative positions. So he's been a tremendous help to us over the last year plus on some of the issues that AIM members have raised. So I thought it was time for you all to meet him in person. One caveat I want to offer at the very start is that neither of us will be giving legal advice today. Intellectual property is so very fact specific that if you have it's going to vary by the fact pattern. So we'll answer your questions, but if you have real details that we need to understand before we can give you specific advice, reach out to Jeff and we'll be happy to do that. Ethan hasn't taken the bar exam, which he'll be leaving us after today to finish up. And so that's why we scheduled it for today while he was still here. I really want to encourage you to ask questions. We have some comments that we're prepared to make, but this will be so much more meaningful if you ask questions. I want to sort of start by thinking back to last year when we last had one of these conversations. I looked up my notes, and it was on March 10th that Jeff had me speak to the group. And on that day, we talked a lot about artificial intelligence and how that was going to impact the classroom environment. We spoke about technology that would allow teachers and administrators to see how much attention students were paying in class and whether they were wandering off with their thoughts, as well as how many bathroom breaks they tried to take. Little did we know that it was going to be a week later that it wasn't AI that was going to be monitoring attention span. It would be parents at home struggling to deal with remote learning. So we can't predict what the future is going to be, but what we do know is that hopefully in September, everyone will be back to an in-class environment. But some of the things that we've learned over the last year of how technology can be used has certainly accelerated what was already a process, and it's here to stay. So we want to talk about the intersection today between intellectual property, particularly copyright, though there may be some discussion about trademarks as well, privacy law, and contracts and licensing. And those are the three main areas that impact your life as teachers and administrators and IT people in education. So with that, I'll get started on the first area. I don't know how many of you attended the session last year, but it always really starts with the same basic information. There are 3 laws that govern the issue of particularly K through 12 education and privacy and copyright's intersection. And then there's fair use, which applies across the board in the copyright arena. So let's talk for a minute about those, and then we'll move into some specifics. The first area is it's FERPA, the Family Education Rights and Privacy Act. And this is a broad statute that probably all of you are familiar with. It prohibits access to student educational records in schools that receive federal funding. So grades, other information about students is supposed to be kept private. The second is Copa, the Children's Online Privacy Protection Act. And that really is going to apply not so much to educators as content creators, but rather as content users. So this is for websites that require parental consent before they collect personally identifiable information about students. It's something that the librarians and the computer folks will need to look at, and it's part of the vetting process before you partner with any third-party applications, but it's not directly related to the teacher experience. The next is Hipaa, and I think we're all familiar with that in the general context of our own lives. And that's the Privacy Act for health insurance, portability, and accountability is what it stands for, but the bottom line is it's that form that you sign when you go to a doctor's office about the Privacy Act. That's really only going to apply to school nurses, and so we won't really dwell on that this afternoon. It also does have some relevance with COVID in terms of identifying those who have COVID and alerting the community to it. But hopefully we're beyond the curve on that, and that won't be too much of an issue going forward. And it sounds like we've been very lucky in the education space that it hasn't been an ongoing problem. The main issue, and it's one, if any of you have interacted with Jeff and asked us questions in the past, we always come back to fair use. And basically, copyright law gives creators, anyone who has fixed expression in a tangible medium, so whether it's music or a book or an article or a lesson plan, any of those are protected by copyright law and should be respected. However, there are exceptions to copyright law, and those are contained in the 4 factors of fair use. And that is most of the questions that we get from Jeff tend to revolve around an analysis on whether the educational use that an educator wants to do can fall within more than one. You need several of those factors. It's a balancing test to see whether you can go forward with your plan. The first is whether the use is commercial or non-commercial. And the knee-jerk reaction is that anything in school should be non-commercial, but that isn't always the case. Sometimes when there's a fundraiser, for example, and showing a movie out on the lawn back in the days when we could do that sort of thing, that might not be an educational use. Or having a Friday afternoon where you put on a movie to entertain the kids because they're just worn out from the week, that wouldn't necessarily be an educational use. Really, it has to be tied to the curriculum. The second test is the nature of the work, and that means that if you're using factual information from a biography or a history textbook or something like that, the facts are not protectable, and that's going to have more latitude in terms of using the material. If you're using a work of fiction as a teaching tool, then you have to be more cautious about copyright law. The third test is sort of a combination. It's really the substantiality of the taking and the effect on the market. So if you're, as we've heard in recent weeks, questions about copying an entire book and digitizing it for your students, that's a lot of taking. That's going to weigh against a fair use argument. If you're just taking a paragraph out of a book, that might be more acceptable. One article out of the magazine. I mean, it really is, again, as I said in the beginning, it's going to be very fact specific whether you can meet that test. And also the test is the effect on the marketplace. So copying a book that is in print, showing a movie that is only available to Netflix or Amazon subscribers, that's going to be more problematic because it's intended that you, as a teacher and as an individual, would be paying for access to those resources. So with that, those are sort of the underlying issues. One that we probably can't go into in much detail today, but is the transformative test. And that is one that it's not in the statute, but it's one that the courts has evolved over time, though recently there's been some pushback on that. And the transformative test is really, are you taking the information and really creating a whole new product out of it? That could be taking material for a lesson plan. There are different things that might fall within that category, but that's an area that's so much in flux right now that we probably shouldn't dwell too much on it this afternoon. So with that, I want to stop for a second, catch my breath, and see if anyone has any questions just about the basics, and then we'll get into some specific copyright and privacy issues.
If
Okay.
anyone has any questions for Carolyn, please feel free just to put them in the chat there, and I will certainly forward them to him. Thanks. I'm not seeing anything yet, so we'll proceed forward. With copyright, there are so many issues we can discuss. What we're going to talk about first is really the TEACH Act. And the TEACH Act is the Technology, Education, and Copyright Harmonization Act. This has been around for a while, but I think it's probably been utilized more in the last year than it had in the previous decade. And basically what the TEACH Act gives, and I hope many of you are familiar with it, it really sort of takes you out of the realm of doing a fair use analysis and gives educators the opportunity to use material for both in classroom and distance education without getting prior permission. This has been a godsend to teachers. It's one that historically has probably been used more at the collegiate level, where you have students that might be in different buildings, or someone in a evening course working from home or something like that online. But it really can apply to K through 12 as well. There are certain caveats, and a lot of the caveats really come from the physical world. So the way the rules are set up is that you can show, for example, a movie to your students,
but you can only show it in pieces, in the course of what is the classroom time. So you might show 30 minutes over the course of several days to get through an entire movie, and that's considered okay. I would imagine that with online teaching, the attention span, you wouldn't show a whole, educational film in one sitting anyway. But you certainly can't do that under the Teach Act. You would still, even though the physical restraints aren't there, about another, class coming into the room in 30 minutes, you can't show the whole thing in one part. So you need to break that up. For those of you that are on the administrative and the IT side, part of the Teach Act requires that you educate your faculty about the restrictions and the opportunities that the Teach Act provides. And teachers should also alert their students, because I think they are going to be confronted with copyright issues throughout their educational experience and certainly in life. And it's always good to model good behavior and to be upfront in terms of explaining to the students why you're doing certain things to protect the copyright interests of authors and other creatives. And so that should be hopefully an easy benchmark to meet. It requires that you only use it for, you're not supposed to really store the material, and copy it over and over again. So it's really sort of a once a semester kind of thing. You can convert it to a digital file and store it. So there's a little bit of issue around doing that. And you can, if a student misses a class, whether it's in the physical classroom or online, you can certainly keep it for the time it takes for them to catch up with the curriculum and see the material that way. So that is probably the best opportunity that you have. Fair use just takes a little bit more thought and is much more fact specific. With that, I think we're going to talk about a couple of different areas of content and how that specifically relates to fair use in the Teach Act in particular. And the first is books. And there are a couple of examples that we've had questions about over the course of the year. We had one question about educator wanting to digitize a book for broad distribution within their cohort or however it was being implemented. And in that case specifically, they were unable, they did do their due diligence and were unable to find who the copyright holder was or where they could get a copy of the digitized version. And in that instance, copyright law does apply just because you don't know who the copyright holder is. The work would still be copyrighted. Copyrighted work are works in the public domain pre-1927, something like that. So pretty much anything that you'd want to use is still under copyright. Copyright does not require that it be something that goes to one of the well-known publishers. It's not something that it's not something that requires you to be a professional author. If you just write down a letter to a friend, it's protected as well under copyright. So in this instance, the idea would be that there's a problem there because there's a balance. And the balance would be that, if there's no market where you can actually purchase the book, you're not depriving the copyright holders of the revenue that they're entitled to for their creative effort. But on the other hand, making dozens of copies for an entire cohort is really more than what's an acceptable amount of taking. If you digitize, 1 or 2 copies, that would be one thing. But a broader application is not there. Someone's asking, is the audio breaking up, and is it just me? Is it just you, or are the people having problems?
You are breaking up a little, Carolyn, on my end.
Okay, I don't know what I can do about that. So, is it terribly garbled? Let's see if I move this over a little bit. Is that any better?
Yes,
I sound
that is a
clear
little better.
Okay, and it says I sound clearer when I raise my voice. I'm always very conscious that I tend to shout on these calls, so I'll start shouting and see if that works. So the books are going to be the primary issue that educators face. But the second one is streaming or posting a movie. And that comes up quite frequently. Posting an entire film on Canvas or a similar platform to that can be risky. It's posting in a fixed medium, and it doesn't fit within the provisions of the Teach Act. So if you've been doing that, that's something that you might want to reconsider going forward. The best option would be to embed the link to a streaming format version. That may not be feasible in every instance, but that would be the best option to take. You can stream it live to your classroom, however that's defined. These days, in limited increments, as we talked about, but you want to be very aware of the terms of use of the service from which you're getting it. And Jeff might want to share, we did an article last year about this topic, but the streaming services each have their own terms of use, and your IT people should be aware of those and let you know, you should always ask first. A lot of issues have come up because educators have their own personal accounts with the Netflix and Hulu and Amazon, and therefore may believe that they can use those accounts to provide movies to their students. That is not the case. Netflix, for example, has a certain group of documentaries that it allows for streaming to classrooms. Otherwise, you need to get specific permission for their use. Hulu and Amazon don't make exceptions for educational uses and underscore that the services are for personal use, and an educator in a classroom is not personal, and it's definitely a public use, even though it's a closed classroom, virtually or online. I think there's been a lot of instances where educators have gone ahead and done this. My guess is in this instance, and as we talk about the general, all of the issues that we're talking about, you may be able to cite an example where someone has been able to do something without consequences. And that's probably likely that in this COVID world, some of the corporate owners are being a little more lax in terms of enforcement. Those days, I think, are thankfully, in a lot of ways, coming to an end. And it's going to be, you need to go back to the old ways of protecting the copyright of third parties. This is one that's not so much a legal issue as an equity issue. But another option that we've had raised previously is that perhaps one could assign students to have a homework assignment to watch a movie at home. And we strongly recommend not doing that. That really raises equity issues. Not everyone may have a good internet connection. Not everyone has access to Hulu or Netflix. And so certainly that would be a way under copyright law to avoid the problem. It is definitely not the way to proceed on a general equity issue. Let's see what else I want to talk about. In that you can retain a copy in a password protected school file, and that would be acceptable. The next issue is story time. I think last year we talked about, we had just had the high school principal that was reading bedtime stories to her students every night, and it got a lot of media attention. And certainly everyone thought that was a good idea and started doing the same thing. Even then, when it was just one user, it was definitely a violation of copyright to read the whole book. You know, publishers had sort of a public relations issue because these were young children that a much beloved story was being shared with them, and there was no commercial intent there. But it did theoretically take away book sales. So during COVID, the publishers came up with a temporary authorization. It's called the School Library Journal's COVID-19 Publishers Information Directory. And it's a hub for getting temporary permission through a Read Aloud permission policy to do this kind of connection with your students now that we're remote. That authorization is going to end in June of this year, and it remains to be seen whether it'll be extended beyond that. Obviously, I think it probably will go beyond June, but it's not necessarily going to be something that's going to be available forever. So one alternative to that is a lot of authors, having seen the viability of this, have their own recordings of their books, and that certainly is a non-risky way to go forward with having that connection with your students. With that, I think I'm going to catch my breath for a second if there are no questions, and turn it over to Ethan, and he's going to talk about partnering with ed tech companies. But first, I'll give you a moment to see if there are any questions. Hearing none, I turn it to Ethan.
I have a question to ask about student-created original products that they may create for a project, and what are their rights as far as what they've created? Do they automatically get copyright protection on what they personally created? Can they take it with them when they leave the school? Or is it school property since it was made for a school project? And I think one of the other issues that goes along with that is often students want to include music in these products. And it's my understanding that if those are shared online, there's a lot of concern about music industry going after school districts for monetary damages for using music without permission. So perhaps those could be also addressed, please.
That's a great question, and I think both Ethan and I will talk to different components of that question. One of the things we were going to talk about is kind of the YouTube video, so I think we'll just move that up in the conversation. But to get to the basic part of your question is students are not employees of the school or the school district. Therefore, the work that they create is not a work for hire within the school community. So if a teacher creates something within the scope of their employment, that does belong to the school or the school district. Student artwork, et cetera, does not, or their video, whatever it might be. There are several things that need to be taken into account. If there's going to be a art show where their work is exhibited in the real world or online, that's usually something that can be taken care of pretty easy with a release form from the students, because again, it's their work being publicly displayed. That may be something that you include in a release at the beginning of the year for art classes, or in your general release that goes to parents, that kind of use is acceptable. You start to cross the line when you use it, perhaps some very talented students' work is going to be used for a fundraiser for the school to buy new art supplies or something like that. Selling their artwork and keeping the profits as noble as the intent can cause problems. So the first issue, the default is the student owns the work. The second part of that question is the third-party content that they use. And I think that this provides an excellent teachable moment for students at the beginning of a project assignment to explain copyright law. And I think it's not that complicated to get through the basics, but the bottom line is that if any third-party use, they're going to need consent. And if someone is particularly talented, one of the ways to get them to abide by that is that, if you just turn it in as a class project and it goes no further than that, the likelihood of anyone raising an infringement claim is going to be slim to none. If a student, for example, does a great project and they want to submit it for, a citywide or regional contest or something, this happens often with filmmakers, that there's a problem, then they're going to need to be able to affirmatively show that they have gotten all the rights necessary and sign an affidavit that they've cleared all the copyrights before they can exhibit their material in a program like that. So that should be a big deterrent to using third-party material. There's some examples where there can be a fair use of the material if it's small enough, but generally you're going to need consent and for anything, whether it's music, whether it's a film clip, whether it's photography. The other issue is going to be privacy issues. If you're filming your friends or taking photographs of your friends for a photo contest, that's also going to be a concern. And I'll let Ethan pick up here and then circle back to me if there's more that needs to be discussed. Ethan?
Sure. Carolyn, do you think I should go into the YouTube discussion a little bit more just to kind of expand on that? Okay, that's what I figured. Yeah. So, Sarah, that was a really great question because we had a whole section about this. So, not only does YouTube come into play when it comes to students who want to upload their music or videos that they make kind of as a creative outlet and a platform. But one unique issue that has kind of come up is that students often, when asked about their career aspirations, say that they want to earn money making YouTube videos. So it also kind of comes into play there. And while the obvious response is don't make it your day job, communicating that reality of, the unlikelihood of fame to a student who has these huge aspirations can be kind of difficult. But there are, just from a practical standpoint, earnings calculators that are actually available online that can kind of illustrate to students how much money can actually be made from YouTube videos. So it can be kind of a practical guide in that discussion. But obviously the more important thing is using it more as a creative outlet and a platform for school projects. It can be useful, but it's also really important to understand that there's a legal framework surrounding YouTube specifically, and it's important to educate students about proper use. For instance, Taylor Swift is one of the most famous musicians on the planet, and she makes a small portion of her living on social media, and it does serve as kind of an extra source of income. But at the same time, it's such a small sliver of that. So, communicating that to students who want to maybe supplement their music careers or their art careers with kind of the use of social media, just to communicate that that's just a small portion of the income that they can make. Again, kind of more of a separate conversation, but now that social media is ubiquitous, it might actually be helpful for schools to include in economics and business classes, if they offer them, to include extensive units on that particular topic, because it could serve students well in the future and could provide more guidance if they just want to start early. But again, that's more of a practical consideration. Now, the legal consideration, first, I just want to talk a little bit about YouTube's terms of service. They typically require parent or guardian consent to use their general services, so the actual YouTube platform. But YouTube does offer a separate YouTube Kids platform that is available for children of all ages. But often you'll find that students are using other platforms like Twitch, which is primarily used for streaming video games directly. And while Twitch is a little bit more lenient on its copyright infringement policies, it's also more geared toward teenagers and young adults. So, in terms of schools just guiding parents there, they should just be wary of each platform and their particular terms of use, because like Carolyn said, kind of previously with this discussion about Hulu and Amazon and Netflix, every platform has a different set of terms of use. So they'll vary per platform. Now, in terms of copyright with YouTube, and again, this conversation is more focused on YouTube. Again, there are a lot of other platforms that students can use, but YouTube is the most prevalent platform that students are using to upload videos. So when it comes to music, there are a lot of copyright concerns that can be accounted for. Mechanical licenses, royalties, there's a lot of jargon there, but there's so much, and like Carolyn said before, when it comes to copyright and intellectual property overall, it can be very case specific and fact specific. So we won't go into too much detail about uploading music that students upload on their own, like their own written music. But in more typical cases, students are going to want to use background music that's already protected by copyright. And I'm sure a lot of you might be aware that YouTube uses an artificial intelligence program to detect content that's already protected by copyright. So music publishers will receive these automatic notifications that their songs are being used without permission. So in response, they might send users copyright infringement notices, which can mute their videos, block the videos, or in the fortunate cases, place advertisements and just claim revenue, and the video will stay up. So the third scenario is the likeliest, but if a video gets blocked or its audio is blocked, especially for repeat offenses, because YouTube does have a 3-strike policy, which eventually leads to a permanent ban. If a student wants to post a video on YouTube for school or for a college application, or like Carolyn was saying, a contest, and they don't want their audio completely disabled, they're better off using openly licensed music. And there is openly licensed music out there, or their own original music, which is a better path. And there is also music out there that's in the public domain for which copyright has expired. Typically, those are older songs, so I don't know how much younger students are going to want to use George Gershwin, but that is obviously going to be a better option because it's no longer protected by copyright. Now, when it comes to uploading existing video content, unless a student can find a direct connection to the owners of certain video copyrights, thinking sports highlights, things like that. A lot of students might want to upload a video of something that a news clip that already happened on television. The best advice here is just to avoid posting existing video content, because even though not all copyright infringement is going to be enforced by owners of specific video content, uploading any video that's already been copyrighted without express permission is straight copyright infringement. So even though a lot of famous YouTubers are using copyrighted clips, truthfully, they've probably secured licenses already from the copyright owners, or they're already so famous on YouTube that the copyright owners would either prefer to place ads on those videos and share the revenue, or they would like to get more exposure on YouTube. So you could argue fair use there, but students should really just err on the side of avoiding infringement by uploading their own video content. Carolyn also mentioned before that privacy on YouTube is really important, because any YouTube content that includes minors is subject to a specific protocol. So students should be wary of posting videos of themselves in addition to other minors. So a lot of students will upload projects of, video projects of themselves in addition to their classmates. When it comes to uploading videos of minors on YouTube, YouTube can only police it to a certain extent. But when they do, they can disable comments, they can disable live streaming, chats, and other certain features that on video posts that involve children, so that so users should be aware that disabling those features may limit a certain audience. So again, if students are posting videos and they're doing it for a college application or some sort of contest, they should know that there's a possibility that uploading videos of themselves, it can be limited in terms of how many people are going to see it, and certain features that may be disabled. Sometimes contests require that people get a certain amount of likes or a certain amount of comments on a video. So those features may be disabled in those situations. Also, YouTube expressly requires that minors who are being filmed and post those videos are being supervised by adults. So that should also be accounted for when they're posting content. But the most important thing is that when students are uploading videos, they shouldn't be, and this may seem really obvious, but it just has to be said, is that they shouldn't be divulging any personal information. For example, while a student could potentially post some, a phone number or something, which is the more extreme example, the more frequent issue could be them just posting an innocuous video about their hobbies or some school project where they talk about what hometown they live in or which school they go to. So while there are some more obvious rules against explicit content and violent content, vulgar content, something as innocent as just disclosing your hometown could potentially lead to unwanted privacy breaches. The other thing is that YouTube is a subsidiary of Google, and Google does tend to collect a lot of data when you are, doing a Google search. They will collect data on that, and when you're an adult, they collect a lot of data about, what you're searching, what you're looking at on YouTube. But even though videos that are marked as "quote unquote" made for children are subject to certain limits on data collection, it's important to know that Google still does collect some data. YouTube Kids, however, is the best platform for children because it has a really broad privacy notice. But when posting videos on the main YouTube channel for general audiences, something like that can expose children to broader data collection. So it's worth knowing both the YouTube policy versus the YouTube Kids policy. And when posting videos, it's more important to post in a channel that's going to be a little bit more kid-friendly and safer. So just generally to the question of how schools can prepare students for using YouTube. First of all, when it comes to YouTube careers, they should know that YouTube is not a standalone career option. But obviously it's a great place for, as an outlet for creativity. And again, it can provide an interesting narrative for a college application essay. And it might be difficult to monitor students' activity online on a broader scale, but it's just a good place for educators to encourage safe online practices among their students, in addition to other social media platforms, which I'm sure a lot of your students are using now that the internet is omnipresent. But it's important to keep them apprised of how to conduct themselves online, of course.
That answer, I think that we gave you a lot of information. Hopefully that answered your question. Still there?
Yes, thank you.
What I think, I'm sort of cognizant of the time constraints that we have. What I want to talk about, two things is, one, I think, Ethan, am I correct that TikTok is one of the platforms where they do provide, you sort of have a bundle of content that users can use without fear of copyright infringement. So that's one option available for the video enthusiast. I want to talk about the flip of this under the broad category of sharenting. And sharenting is a word that is obviously a mix of, it comes from oversharing by parents of photographs of their, and the life story of their children really from birth forward. But I think it has real practical implications for educators as well on two fronts. One is that as a trusted source for parents, it can be useful if educators explain some of the risks to their child's privacy of oversharing information about the students. But more importantly, schools have kind of jumped on the same bandwagon, and schools now have their own website. They post videos of the football game, of the concert that the students participate in. And you really need to be very careful about the privacy issues surrounding posting children's pictures and other identifying information online. If you got the name of your school, then, and a child is visible in a video, that could open them up to cyber stalking. It can, expose them to embarrassment, among their peers or a broader community. It can lead to bullying. It creates a digital footprint. And once that footprint is created, whether it was their parents' actions before they entered the school system or during the school system, that's going to carry with them for life. And it's something that college admission counselors are going to be able to see, potential employers are going to be able to see. And so I think schools need to really do a balancing test about how much that they want to acknowledge the achievements of their students and tout what a great system they have versus protecting the youth that they're that are under their care. So with that, I think I want to open it up for some more questions. We've got some more things that we can definitely share with you, but again, your questions are more important. Well, if not, then you want to circle back, Ethan, and talk for a minute about ed tech companies.
Sure. That works for me. I'll try to keep it brief and with some more pauses maybe this time. So distance education and remote learning is no longer a foreign idea. And the important thing when it comes to partnering with these third-party companies that provide tech services, so video conferencing like Zoom, academic data analysis like Illuminate, and more interactive experiential learning activities. It's important to kind of bridge the gap between addressing privacy concerns and security concerns with also not trying to limit the use of technology so broadly as to limit learning opportunities. Partnering with these ed tech companies goes beyond just privacy law, even though that's kind of the focus of the conversation here. It's also worth considering that students who have special needs may need certain software to accommodate those needs. And the other thing is that some students have very limited access to technology or technology that's compatible with certain software that you're using. Obviously, there are privacy problems like security breaches, accidentally disclosing personal information, students misusing certain hardware or software that you're using. There's also the issue of in addition to that, the fact that there are no longer in-classroom assistants who are physically there. For example, one-on-one special education aides, certain therapists that are there physically in person. Obviously, with the remote classroom, that's not a possibility. So there are a lot of ways to kind of bridge that gap. The first thing is to just make sure that you're researching these third-party vendors. Obviously, everyone knows about Zoom bombing, where kind of toward the beginning of the pandemic when people were logging into Zoom on more public channels, people were able to, or hackers were able to get into those Zoom conferences and kind of invade them in an unwanted way. But there are a lot of trusted communication services. Zoom has upgraded its policy and added a lot of guidance in terms of creating password protected rooms, et cetera, but Microsoft Teams, WebEx, they're all very trusted. And some states, for example, Connecticut, I believe it was in April of 2020, disseminated some guidance as to what its state government considered the safest companies. So it's also worth looking to your state government for that information. Another thing is to just make an inventory of all the contracts that you have with these third-party companies. Obviously, it's important to keep track of laptops and tablets and chargers when they're actually distributed to students. But it's important to be more scrupulous now. But in addition to these contracts that you have with third-party companies, it's also important to just keep a record of any sort of acceptable use policy or liability waiver releases that are signed by families and students at the beginning of the year to just ensure that those policies are being adhered to. Under Copa, which is one of the laws that Carolyn discussed a little bit earlier, schools can technically, when they're in person, act as agents for parents when they're partnering with third-party software providers. So it's worth reconsidering just rewriting really clear parent and guardian releases and ensuring that they reflect the most up-to-date current academic and extracurricular environments for a new school year. And also to just make sure that those contracts that you have with these third-party providers comply with FERPA and Copa and all the laws that Carolyn addressed at the beginning. Another thing is just addressing the absence of these in-classroom assistance with adaptable technology. With breakout rooms, it's helpful, but per the U.S. Department of Education, schools are required to provide the same services to students with disabilities if the general student population is receiving them. So obviously interactive tools are helpful and breakout rooms are important, but it kind of goes beyond the Disabilities Education Act, the Individuals with Disabilities Education Act, and the Americans with Disabilities Act. A fourth thing is to just make sure that if possible, everyone in the school has access to high-speed internet by potentially partnering with cable companies or telecoms providers. If it's possible, I know that the Massachusetts DOE partnered with a bunch of public media outlets to provide those alternatives for students who don't have high-speed access. And if those partnerships don't fall within the school budget, it might be worth actually reaching out to those media companies to see if there's any kind of workaround or pathway to help. One of the things that Carolyn and I had discussed at length was when it comes to the digital divide and just economic inequality overall, it might be worth discussing requiring school logos as virtual backgrounds or allowing students when they are remote, in the remote or hybrid context, to opt out of providing a video feed. Because by establishing those norms, students are kind of on an equal playing field, and it can prevent discomfort that results from economic differences that can become really apparent when students' homes are just on display for the whole class. For example, a student sharing an apartment with 7 other family members versus a student logging on from their vacation home in Turks and Caicos could create some discomfort there. And the other two things, sorry, go ahead, Carolyn.
I think, Jeff, we have a few more minutes to go, but we want to be good stewards of everyone's time. What would you like us to do?
Are there any questions for the group?
Doesn't sound like it.
I do say the whole idea of the backgrounds and as well as allowing students to opt out, that's certainly makes a lot of sense, for schools from that whole equity perspective.
Yeah, I mean, and it's a great way of showing school colors as well. The one final thing is that there are open educational resources that is material that's in the public domain, and that may be something to be able to supplement the content that you're using in the classroom. So we didn't get to talk about that in any depth, but we're available if there are any other questions. We invite you, Jeff, I can send you a link if you don't already have it, to we've done some frequently asked questions in the education space, and everyone is welcome to visit that site, and as well as reach out to you for any questions.
Great, I'll be happy to share that with the group, and hopefully we can do this again sometime.
Well, we'll definitely make it an annual event, if not sooner.
Awesome. So, okay, well, thanks so much, everybody, for joining us. Again, if you have any questions, you can feel free to email me, and I hope everyone has a great rest of the day.
Bye, everyone.